If you care about the future of American institutions, you need to pay close attention to what I'm about to explain. Subscribe to this channel and turn on notifications, because what unfolded today inside a federal courtroom in Manhattan was not just another legal development. It was a real-time stress test of whether American democracy can still function when powerful people decide the rules no longer apply to them. Here's what we know. At approximately 11:47 a.m., during active federal court proceedings, 3 of the most highly paid defense attorneys in the country stood up from the defense table, collected their materials, and attempted to leave the courtroom while a federal judge was still speaking. Let that sink in. Licensed officers of the court, sworn to uphold the Constitution, attempted to abandon their client and exit a federal trial simply because they disliked a ruling. What happened next is something that has not occurred in a federal courtroom in more than 20 years. Let me walk you through the sequence, because the details matter. The morning session began routinely. Prosecutors sought to admit financial records. The defense objected. Nothing unusual for a complex white-collar case. But the real story begins 48 hours earlier, due to a clerical mistake. A sealed filing was accidentally uploaded to PACER, the federal court's electronic records system. It remained publicly visible for exactly 17 minutes before being taken down. In that short window, legal researchers captured the document. According to multiple sources who reviewed the material, the filing contained newly obtained evidence, encrypted communications between Donald Trump and his co-defendants during a time period the defense had repeatedly claimed there was absolutely no contact. The documents reportedly included wire transfers totaling $4.7 million and what one source described as the most extensive financial paper trail ever assembled in a white-collar criminal prosecution. This morning, Judge Patricia Caldwell ruled that all 847 pages were admissible. That's when everything collapsed. Lead defense attorney Robert Sterling stood and stated on the record that the court had abandoned any appearance of neutrality and that the defense would not participate in what he called a predetermined proceeding. His co-counsel added that the prosecution's conduct was unethical and that they refused to legitimize the process by remaining present. Then they began walking toward the exit. Now, understand who this judge is. Patricia Caldwell is a Reagan-appointed federal judge with 31 years on the bench. She is widely respected, known for restraint and fairness. Defense attorneys often consider her courtroom a favorable venue. She looked directly at the attorneys and said words that are now part of the official transcript. "If you take another step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." She then ordered U.S. Marshals to secure the courtroom. Within seconds, 6 armed federal marshals blocked every exit. The standoff lasted 7 minutes and 23 seconds. And this is where the story gets much bigger. Judge Caldwell then revealed that earlier that morning she had received a sealed ex parte submission from the Department of Justice. For those unfamiliar, ex parte filings, where only one side is allowed to see the material, are extraordinarily rare. They are typically reserved for national security or witness safety concerns. The judge stated on the record that based on this filing, she was considering heightened security measures and possible jury sequestration. Every experienced defense attorney immediately understood the implication. Someone has flipped. Former federal prosecutor Andrew McCarthy explained it bluntly on Fox News. When defense lawyers hear about sealed ex parte submissions in a case like this, they know the walls are closing in and a cooperating witness is about to change everything. Within 30 minutes of being forced back to their seats, Sterling's team filed emergency motions for a mistrial and for Judge Caldwell's recusal, claiming bias and misconduct. This is critical. By staging a dramatic confrontation, the defense created a foundation for appeals regardless of the verdict. And the coordination did not stop there. Fox News camera crews were reportedly positioned outside the courthouse nearly an hour before the walkout attempt. Conservative commentators were already tweeting about judicial tyranny before the incident became public. That timing is not accidental. The sealed DOJ submission reportedly involves testimony scheduled for next Tuesday from an individual identified only as Witness 14. This person allegedly has direct knowledge of the financial transactions at the heart of the case and has been in protective custody since October. Protective custody is not routine. It is typically reserved for cases involving organized crime, terrorism, or national security risks. Legal analysts believe Witness 14 may be someone deep inside Trump's financial operation, a controller or CFO-level insider with first-hand knowledge. If that testimony unfolds as prosecutors expect, the consequences for the defense could be devastating. Judge Caldwell later stated she is considering appointing shadow counsel to sit at the defense table, backup attorneys prepared to take over immediately if the current team attempts to withdraw again. This is an extraordinary step, taken only when a court believes defense counsel may attempt sabotage. Financial fallout followed quickly. Sterling's firm has billed over $12 million in legal fees. Bloomberg reports the firm has entered emergency discussions with its malpractice insurer, which is reportedly concerned about exposure if the walkout attempt results in mistrial or appealable error. Partners could face personal liability. Friday night, senior partners were seen entering the firm's Manhattan offices for what sources described as crisis talks. The implications extend far beyond this case. If attorneys can simply walk out when rulings go against them, the entire judicial system collapses. Judge Caldwell addressed this directly, stating that allowing such tactics would encourage defendants to manufacture mistrials through staged disruptions. History supports her concern. In every modern instance where attorneys attempted similar behavior, the defendants were ultimately convicted, and the lawyers faced severe consequences. The political reaction was immediate. Trump posted on Truth Social praising his lawyers and accusing the judge of election interference. Republican senators weighed in, some condemning the judge, others emphasizing the rule of law. A Reuters Ipsos poll found that 67% of Americans, including nearly half of Republicans, disapproved of the walkout attempt. Even Alan Dershowitz called the move indefensible. Perhaps most troubling, a defense paralegal claims Sterling received a text minutes before the incident containing 2 words, "abort mission," allegedly sent by a senior Republican strategist. If true, this raises the possibility that the courtroom drama was coordinated for political purposes. Judge Caldwell appears to believe that as well. In a written order, she stated the court has reason to believe elements of the disruption were orchestrated with outside parties and warned that any future attempts at political theater would be met with severe sanctions. Security has since been escalated. Additional screening was installed. Federal agents were placed on standby. Individuals linked to extremist groups were reportedly identified near the courthouse. International reaction followed. European legal experts expressed shock. Foreign media described the incident as evidence of instability in American institutions. Meanwhile, sources say Trump is considering replacing his entire legal team with more extreme attorneys, further complicating the judge's options and potentially delaying proceedings. This is no longer just a legal case. It is a test of whether American courts can function when defendants attempt to turn trials into campaign events. Judge Caldwell will rule Monday on the mistrial and recusal motions. Witness 14 is scheduled to testify next week. U.S. Marshals have reportedly been briefed on arrest procedures for attorneys, something unheard of in modern federal courts. The stakes could not be higher. This is about whether the rule of law still means anything when wealth, power, and politics collide. Whether courtrooms remain places of justice or become stages for performance and manipulation. Subscribe, stay informed, and share this with anyone who cares about whether American democracy can withstand this moment. Because what happens next will echo for generations.